And with that, I'd like to welcome our witnesses here today from the Department of Fisheries and Oceans. Mr. Peter Lamberti, National Chief Enforcement Officer, welcome back. We have Paul Didham, the Supervisor, Major Case Management, Newfoundland Region by video conference. We have Neil Jensen, Chief of Recruitment, Training and Standards, Pacific Region by video conference as well. We have Trevor Lushington, Fisheries Officer, Ray McLeave, Program Officer, On-Site Training Coordinator, also by video conference. And then we have also Mr. Jeff Thorburn, Fishery Officer and Acting Habitat Coordinator, Vancouver Island and Sunshine Coast. So I understand most of you would like to make a short opening statement, and I will allow it, with the understanding that we may extend this hour by about 10-15 minutes if members want to have their full questioning time. So we're going to start with the opening statement for Mr. Lamberti.
Thank you, Mr. Chair, and good afternoon, committee members. I am pleased to be here today on the traditional territory of the Algonquin Aninashibig people, and I would like to thank the committee for their interest in the work of conservation and protection and for inviting fishery officers to appear before you today. I am incredibly proud of the work done by all our officers across this country, coast to coast to coast. Recognizing that today is my third appearance before the committee in recent weeks, and the value in having frontline conservation and protection officers before you as witnesses, I will keep my opening remarks very brief, allowing the officers more time to read their opening remarks, and so the committee can maximize the time they have for officers' testimony. Thank you.
Thank you very much, Mr. Lamberti. Next, we'll now hear from Mr. Jensen.
Mr. Chair, thank you for the opportunity to speak here for the first time. I'm Neil Jensen, the Chief of Recruitment, Training and Standards for Pacific Region. I've had a diverse and extensive career in Pacific Region, serving as a General Duty Officer and Supervisor in the BC Interior, the South Coast, Lower Fraser, and the BC Aquaculture Enforcement Unit before coming in as a Regional Manager here at headquarters. Over that time span, I've seen a lot, including many ups and downs, the evolution of the Conservation and Protection Program to what it is today. I've enjoyed many experiences and achievements over the years and still love the job as much as when I first joined many years ago. You'll hear many interesting insights from my colleagues today, and I look forward to answering questions. But I want to highlight two key topics of interest. First, revising the Fisheries Act. In doing so, a top priority should be to enable better traceability to prevent fish laundering. Currently, proving or getting charges approved for larger investigations into illegal fish sales is almost impossible. Stronger traceability would be a game changer for officers and a major deterrent to fish trafficking. This is a significant issue in Pacific Region and needs to be addressed urgently. My second point is towards fishery officers and in relation to the peace officer status of them. For many years, the Criminal Code's definition of fishery officers as peace officers has been unclear, creating confusion about when they hold that status while on duty. Recent opinions leave officers uncertain about liability coverage and legal authority. At times, they may be viewed as private citizens despite being armed and in uniform. Other times, they're acknowledged as full peace officers. It's not something that can be just turned on and off with a switch. Officers do not feel supported in their authority and protections, and uncertainty could cause hesitation at critical moments, leading to harm or other negative outcomes. Clear, consistent peace officer status is essential for officer safety and public trust. And that just concludes my brief statement, Mr. Chair. Thank you.
Thank you very much. And we're now going to hear from Mr. Lushington.
Good afternoon. Hello, my name is Trevor Lushington. I've been a law enforcement officer for 32 years in total, 25 with Department of Fisheries and Oceans. I'd like to share with you, or I'm here today to speak about barriers in law enforcement in regards to the Fisheries Act. I'd like to share with the group that in the last 5 years, there's been significant barriers presented to us in law enforcement. Our work as a fishery officer has got a lot more dangerous. conflicts have increased with the fishery officers and the work that we're doing. And that conflict, it's resulted in our ability to have less impact to protect the resources. So if we looked at what happened in the last 5, now I would like to take a second and look at what's happened in the last 5 months. We've seen a significant change. We are able to demonstrate that now with the work that we've done that's being posted, that's being shared with you guys. We have new communication lines with our enforcement chief that go directly with the Minister of Fisheries. We've saw a number of pieces of equipment that have been handed over to fishery officers to make our work much more safer. These would include drones and body-worn cameras. We have more operational vessels that we're able to use and put in key strategic areas where they need to be and when they need to be. So I guess in closing, I've been following along the work that this committee is done. And honestly, I'd like to say thank you to each and every one of you. You are making our job better, and the boards that you're trying to lift up and see what's underneath it, we appreciate it. It is going to make our job better, and we're protecting a resource that I honestly care a lot about. I'd like to leave you with a short comment that I remember as a younger fishery officer in a judge in a courtroom in Shelburne. And the judge said, "These fisheries are the lifeblood of our communities. They mean a lot to us." And I'll just go right back to the beginning. I look forward to hearing some questions from you. So I cut my 5 minutes down because I wanted to hear what you had for questions as we reach the end of your sessions. So thank you for the opportunity to speak.
Thank you very much. And with that, we're now going to hear from Mr. Thorburn.
Thank you, Mr. Chair, and members of the committee for the opportunity to speak today. I'm here to provide a frontline perspective on challenges fishery officers face enforcing the Fisheries Act across Canada. My comments reflect daily operational realities by officers in the field. Number 1, lack of charge approval for files involving indigenous harvesters. One of the most consistent obstacles in obtaining charge approval for investigations involving unauthorized harvest by indigenous individuals or groups. While we respect treaties and rights-based fisheries, some activities clearly fall outside established agreements, jeopardizing the conservation and protection of fish for all Canadians, including other indigenous peoples. Yet the threshold for prosecution is so high that many files did not receive the charge approval despite months and years of effort by fishery officers. This creates inconsistent enforcement and undermines our officers' ability to apply law fairly and uniformly. Number 2, lack of traceability in the supply chain. Canada does not have a full end-to-end traceability system for fish moving from harvest to market or accurate reporting of food, social, and ceremonial catch. As a result, illegally harvested fish, including non-saleable FSC product, continues to enter the commercial supply chain with little ability to confirm origin. This harms legitimate harvesters, including indigenous, commercial, and recreational fishermen, encourages black market activity, and increases food safety and export risk for Canadian markets. Number 3, organized crime exploiting fisheries and the need for peace officer status. We are seeing increased involvement of organized crime groups using indigenous harvesters and their rights as a means to launder illegal fish. These individuals from indigenous communities who participate in this laundering take food away from their own people and, in the long term, the necessary conservation and protection measures to ensure moderate livelihood. Our officers often lack the investigative resources, the interagency communication, and most importantly, support from indigenous communities needed to confront these networks. To combat organized crime, fishery officers require peace officer status. This will allow us to enforce legislation outside the confines of the Fisheries Act, providing needed tools to meet organized crime head-on. Our current enforcement structure is not built to counter the sophistication and scale of our criminal groups active in the fisheries sector. Therefore, we need peace officer status to give us the tools to reach outside the authority of the Fisheries Act. Number 4, insufficient number of officers, limited budget, and chronic underpayment. Fishery officers cover a vast geographic area with staffing levels that did not have kept pace with modern pressures, including rights-based fisheries, commercial expansion, and habitat complexity. Many detachments operate with minimum staff, leaving capacity for proactive patrols or complex investigations difficult. In addition to being understaffed, fishery officers remain significantly underpaid relative to the risks and responsibilities of the job. We work armed in remote locations in harsh conditions and frequently deal with organized crime, dangerous vessels, and high conflict encounters. Yet compensation often aligns more closely with trades such as window cleaners or fish hatchery technicians, who face none of the statutory safety or enforcement responsibilities fishery officers carry. For an officer to earn a full field level officer pay, it takes 7 years. Fishery officer trainees require 3 years of training prior to graduating as a full-fledged fishery officer and 4 more years to get paid a top-level GT4 officer wage, the longest training period of any enforcement agency in Canada. Number 5, examples of setbacks when changes to the Fisheries Act are made without foresight and ideas for habitat compliance in the future. In 2012, changes to the Fisheries Act shifted protection from all fish and fish habitat to only those supporting economically viable fisheries, forcing fishery officers to prove both commercial value and serious harm to fish, leaving many species without protection. Recent revisions since 2019 have restored protections for all fish and introduced tools like corrective measure orders, which allow proponents the opportunity to fix non-compliant activities. However, officers still lack a timely, impactful way to address minor violations, and one proposal is a licensing system to ensure work around fish-bearing waters are being carried out responsibly. Each license comes with a condition of license, much like that of a commercial fishery, allowing fishery officers the ability to issue tickets for less serious non-compliance issues. However, have a more immediate impact ensuring conditions of the licenses are complied with in a more timely manner. Number 6, lack of direct communication between management and frontline officers. Many policy and operational decisions are made without meaningful input from the officers tasked with implementing them. This disconnect leads to policies that cannot be practically enforced, unclear operational expectations, and inconsistent application of the Act across regions. Frontline enforcement and management insight should be built into decision-making rather than added after the fact. Incidents such as those in southwest Nova Scotia where officers were suspended and persecuted after an arrest for illegal overfishing is a stark reminder to officers that there are limited protections from the political will of the day should enforcement action garner negative media attention. In closing, we need more officers, support staff, and vastly improved pay structure, peace officer status, and the legal support to keep pace with the pressures on the resource and the complexity of the enforcement environment. Lastly, our agency is the oldest enforcement agency in Canada. We stand on the backs of fishery officers that came before us. We need the recognition we duly deserve as frontline enforcement officers. In the past 2 years, our support networks have missed the opportunity to ensure we are recognized as frontline enforcement officers. And we need our government's support to ensure there will not be a third. I thank you, and I look forward to your questions.
Thank you, Mr. Thorburn, and we're going to last hear from Mr. McLeave.
Mr. Chair and committee members, thank you for inviting us to testify today. It's my pleasure to be here to speak to the operational legal challenges that fishery officers experience in enforcing the Fisheries Act. My name is Ray McLeave, and I have been a fishery officer with DFO for 25 years. Most of those years were spent as a frontline officer, field supervisor, and eventually a detachment supervisor in both the Gulf and Maritime regions. Prior to becoming a fishery officer, I was a deckhand on board a lobster fishing vessel in Southwest Nova, an LFA 34 for 5 years. In addition to my current position, I'm also on the National Executive of the Union of Health and Environment Workers as Regional Vice President for the Scotia Fundy region. Throughout this study, you've heard many allegations of fishery officers not enforcing the Act. I hope my testimony can shed some light into the complexities of our work and balance your views. First, let's face it, doing more with less is not practical in our line of work. We've used to have detachments with 10 or more officers, and now we try to operate with half of that or less. Fishery officers cannot possibly respond to every complaint. We operate with limited resources, both in terms of finances and personnel, to protect Canada's fishery resources along the longest coastline in the world. The retention of personnel is an ongoing issue, and wages based on a 1969 job description for glassblowers does not help matters. Once trained, new officers often decide to pursue alternative law enforcement careers with a federal or provincial law enforcement agency, which pays substantially more. Fishery officers do not have a public safety mandate. While our uniform, duty belt, and service weapon may lead the public to mistake us as police, fishery officers do not have the same powers as police. Our peace officer status is functionally limited to the performance of our duties under the Act. We do not have the mandate authorities, or legal protections to act as peace officers in matters outside of the Fisheries Act, such as physical altercations between harvesters on the water, possession of drugs, or driving under the influence. Those are matters for the police of local jurisdiction to handle. If our conscience and personal morals bring us to act in a situation outside of our mandate, we do so at our own risk, as simple citizens with no guaranteed protection provided from DFO. As fishery officers, we do have vast inspection powers. Officers must apply these powers in a reasonable and lawful manner to ensure the integrity of the department and those who represent it. When we have reasonable grounds to believe that a violation has occurred, we do investigate. As fishery officers, we use our discretion to decide the level of enforcement to engage in, ranging from education, warning, to full investigations and up to the laying of charges. As Government of Canada law enforcement officers, we are bound by the strict authorities granted to us by the Fisheries Act and the Criminal Code, and we must uphold the legal protections that are guaranteed by the Canadian Charter of Rights and Freedoms. To bring charges forward, we must show to the Public Prosecution Service of Canada that there is, one, a reasonable prospect of conviction, meaning that we can prove beyond a reasonable doubt that the person committed the offense. And then second point would be that it is in the public interest to prosecute. As you've already heard, PPSC determines this, not fishery officers. This committee has heard allegations that fishery officers did not take action against potential illegal fish harvesting, or that they failed to use information provided to them by members of the public, including industry. It needs to be clarified that although members of the public may not feel that the work is being done in relation to illegal fish harvesting, the actions that are taken cannot be shared with the public outside of proceedings that have been put in front of the court. Doing so would be a severe violation of a person's charter rights, which we must uphold if there's any hope of achieving a successful prosecution. Fishery officers enforce the Act and the regulations. When it comes to license conditions, those are imposed by DFO officials in the Resource Management Branch, insofar as those officials impose conditions that are within the legal authorities of Section 22 of the Fishery General Regulations and duly consulted with impacted First Nations when relevant, those license conditions would be enforceable and actionable by fishery officers. I hope that this clarifies the operational and legal reality in which we operate, and I would be happy to answer any questions. Thank you.
Thank you very much, Mr. McLeave.